That day, I think Mr. Purohit was not there on the last occasion when we closed it. The order sheet reveals that Mr. Purohit was not. So we are releasing it to be heard by the bench, roster. This matter was taken up on 14/10/2025, on which day Mr. We cannot fix a date, it will come. You move before the roster bench.
Special urgent matter item number 2.
Meet legal article. We are on the last day, 28th January, your last day, directed my learner friend to take instruction as to when he will vacate the premises in question.
I have obtained instruction.
I have also filed an objection to the affidavit filed by my SPCL, my learner senior. The objection that 6 months time is quite unreasonable, and for that my learned senior have taken time to obtain instruction when he will back. And second thing, my lord, my humble submission is that as per the order of this honorable court dated 10/12/2025, I was supposed to file the list of documents and the calculation sheet and the affidavit. I humbly pray that I will be filing it by tomorrow, my lord. Everything is ready. I pray that I will be filing it by tomorrow.
You have already filed.
Lord, I have filed an affidavit pursuant to your lordship's direction, Lord, dated 10/12/2025. In the affidavit, Lord, I most respectfully, Lord, bow down to the observation of your lordship's court as to a 6-week reasonable period, Lord. I came back to your lordship. If your lordship takes the affidavit dated 23/12/2025, I came back to your lordship, Lord, outlining the steps we need to take as a public sector undertaking to vacate the premises. And in the meantime, Lord, as has been directed by this honorable court, via a judicial order of a rent value, Lord, I undertook that we shall continue to discharge the rent value. And Lord, we on affidavit stated that we will vacate on the 30th of June 2026. Pursuant to your lordship's observations on the last day, Lord, I have obtained the instruction. The process has already been initiated from December itself, Lord. And if your lordship would be pleased to kindly accommodate me till 31st of March 2026, we would be able to vacate the premise and remove all the underground equipments, etc., which are essential in terms of the Explosives Act, etc. That is my respectful submission as per instructions, Lord. It would not be possible to vacate prior to that, Lord, because certain statutory obligations are there, the GST accounts, etc., have to be closed. As well as, Lord, I have to surrender my explosive license, which is a sine qua non for operating a petrol station. The earliest possible would be, Lord, 31st of March 2026. That's my respectful submission. Insofar as, Lord,
It will not go beyond.
It shall not go, Lord. I shall ensure it. Lord, I have had a meeting, I have had a conference call at the highest level, Lord, and I have conveyed your lordship's mind. And in obeisance to your lordship's observation, Lord, and mine, 31(3) shall be adhered to, Lord, without fail. And the process has already been initiated to scale down the operations. We shall exit prior to that.
Is it not reasonable, Mr.? Mr. Jan-
But is it
Mr.
not reasonable court purchase?
Again?
Is it not reasonable court purchase? 31 March 2000?
Yes, Milord.
Yes, sir. He has taken
Milord,
instruction.
this is no Milord. Whatever order we pass, I. Only prayer mind is that.
Affidavit, I think.
Lordship, my record my statement, Milord, I received the written
No, Mr.
instructions.
No, Mr.
I'll file an affidavit.
From
Affidavit
of
of undertaking,
Definitely.
saying that you will vacate on or before 31st of March 2026.
As a Lordship. It shall be done.
and that to consider, my
The-
lord,
And
and we are
20,000
of the,
rupees.
that
how can
amount
it be
also
said
you
to
should
be a
consider.
reasonable one.
A reasonable amount
Not-
to your,
not-
to your prudence, doing the business.
Not respectfully, most respectfully, my instructions are not to stick to the 20,000 figure. Lordship will see the-
We will direct the mean profit to be ascertained. If there is a nearby property which is let out having a market rental value more than that, then that has to be paid.
Lordship would kindly see the prayer in the writ petition. This is a writ
Now
petition.
then this will be non-ending process.
No, that's
There is
why-
a judgment of a Supreme Court in Khadak Singh Bait.
But my respectful submission would be, if your Lordship is inclined to fix an amount, Lordship would be pleased to fix a reasonable amount, but I will not come in the way.
We
But
can't
so far
even
as
say
mean profit is
the,
concerned,
sir, when the order for vacating the premises was passed, you could not get that order set aside. The moment this order is staring at your face, your occupation in the property beyond that is absolutely wrongful.
Your
If-
Lordship would
if
kindly take
it
the order
is-
dated 23/12 for a 10/12 for a moment. Kindly take the order dated 10/12 for a moment.
Read,
The petitioner was called upon, my lord, in the last paragraph to file documents and affidavit with calculation fee. He has filed the affidavit.
No, he wishes to file another
My
affidavit.
lord, it's an unending litigation from 2000
That is-
onward.
that is
My
what-
is
that is what-
under order 20 rule 12 of the Code of Procedure.
lord,
Read
order 12, rule 12.
order 20 rule
Rule
12.
12, my lord, speaks about adjudication in a civil suit, my lord.
I'm understanding.
My lord,
When an eviction is passed, can we not borrow that principles?
my lord, most respectfully, my lord, insofar as mean profit is concerned, my lord. if
That
this
is what
was-
I am reminding you of Khadak Singh Bait's judgment.
Lord, it would not apply to the facts and circumstances.
Why
of the
will
case,
not-
Most respectfully.
If you have suffered an order of eviction,
My lord,
if
there is no
you,
order of eviction, my lord.
then how the vacation order is there?
My lord, Lordship takes the order. This is not, my lord, to clarify, my lord.
I am-
This is not arising out of a civil suit.
I am again asking you, sir, very simple way, whatever be the proceeding, be it a writ or be it a suit, there is an order for eviction passed against you that you'll have to vacate. I think it is undeniable
My lord, most
situation.
respectfully, there is no order of eviction.
Then why the court is always insisting for vacating? Why the court fixes a amount of rupees 20,000 to continue? Why?
My lord,
I'm
may I
just
take your
asking
lordship
this
to the-
question.
Yes, sir. I'm obliged. Then may I take your lordship to the proceedings, which happened from 2022 on.
I am asking you when the order for eviction was passed.
There is no order of eviction, my lord.
Then how you are allowed to pay, or why you have been compelled to pay 20,000?
My lord, may I take your lordship, my lord, to order dated 22/2/2022 of your lordship.
Sir, order dated 10/12/2025 is very clear.
No.
Speaking that he fairly submits that the SPCA does not have any legal right to occupy the land beyond 31st October 2015.
This is what, now you tell me there was a lease. Must be a lease, there must be an agreement. there must be something. You cannot claim to be the owner of the property.
Lord, kindly see the writ petition.
I am asking you, are you claiming ownership of the
Lord,
property?
please permit me to place the writ petition.
I am again, now I'm talking in a civil sense.
Lord, I am not claiming title on the property.
Property. You are in occupation of the property.
Yes,
Not
from
in-
1963.
Whatever.
Lord,
There must be on the basis of some authority, some agreement, some deed.
yes.
What is that deed, nature of the deed?
Well,
Lease,
1963.
or an open tenancy, what
No, Lord, it's a lease deed.
is a lease deed? Duration must have been shown in the lease deed.
Absolutely.
The lease expires by flux of time,
Lord, way back.
2013. I'm asking,
Lord,
2013,
2013. Lord, fairly speaking, it is prior to that.
fair enough. Then
From
second
93,
question.
there is no agreement.
I am again, sir. Then there is a undisputed fact that after the expiration of a period, whatever,
Lord,
you continued in occupation.
from 2013 onwards, yes.
You continued in
Yes.
occupation. Under what authority or law or a right you continued?
Lord,
Show
negotiations,
me
it's-
one
You're-
thing, under what authority, right you continued in possession.
Lord, this petrol pump, the lease deed is signed under the Caltex Act. My predecessor, under the Caltex Act now. My predecessor company, wherein I was not in existence, signed the lease deed. Now, in the Caltex Acquisition of Properties Act, I was given a right as Hindustan Petroleum pursuant to nationalization, wherein I could have
I'm
got-
again asking, when the predecessor company was already a lessee under him or his predecessor, let us proceed on that basis. Then once you step into the shoes,
Lord,
either by virtue of I think the operation of law,
operation of law.
or by virtue of
Lord,
any contractual obligations,
Lord.
you cannot elevate your status from a status of a lessee to a status of a perpetual lessee.
I would like for that, Lord. Therefore, I stated, Lord.
Now, second question.
Lord, permits me for a moment.
Now, second question, sir.
yours-
Again, when you have come, then I'm asking in a civil perspective law. Suppose a company has undergone a liquidation. I'm giving you a hypothetical example.
Lord,
Undergone a liquidation. The liquidator is appointed.
Lord.
The moment the company is under liquidation, according to your understanding under the Caltex Act or something like that,
Lord.
so that is also under the Companies Act. Does it absolve the liability of on outgoing company to pay the rent to the lessor?
Lord, it does not. And in this
Secondly,
Lord.
a company has gone under SICA.
Lord.
You know, before IBM came, the SICA was there.
1985 onwards.
SICA, it has gone to a BIFR,
Lord.
applying for, the liquidations. Does it absolve such companies? Suppose the application is admitted, and under the SICA there is a moratorium period which is provided. No proceeding, nothing
Section
can be
Section
initiated against that company. Does it absolve the company from paying the rent as it has gone into SICA and the application has been admitted?
No, it doesn't.
Chamundi Moppet case of a Supreme Court. I am just reminding, I am just giving you all those references. Chamundi Moppet case, read, it says no. Your obligation to pay rent continues even if your application is admitted by a BIFR.
Only legal proceedings are state.
I'm telling you, the recovery and all, everything that was state. Even he can file a proceeding for eviction.
Yes, very
That is not state under the SICA. No moratorium. That is what a Chamundi Moppet case that the Supreme Court has held. Third, a company has applied for sanction of the scheme of merger. The High Court at that point of time, now it is
NCLT.
gone to the NCLT, sanctioned that particular scheme of merger. The company which is a lessee under a landlord merged with the another company by virtue of an order of the court. Does it not tantamount to an unjust enrichment on the rights of a landlord? Does that transferee company becomes directly tenant under the landlord by virtue of an order of merger?
Just to answer.
No,
Just to answer.
no. Again, there are judgments of the Supreme Court.
No, but this is not on these.
That's I'm asking gramophone. When you talk about Caltrex,
Below.
that is why I'm reacting so much on that.
Below.
It hardly matters that whether you come by virtue of a takeover, when either you come by virtue of any statutory the recognitions. Once the right vis-a-vis an individual, a third party comes, your status remained the same. You cannot elevate your status. That is the bottom line of the story. I just wanted to percolate on you.
Now, may I just place?
Only exception is involuntary transfer. Is the only exception. Any voluntary transfers will not disturb the very fabric of a relationship of a landlord and a tenant or a lessor or a lessee. It remains. Once you are there, you cannot occupy beyond the period provided for your occupation. If you continue, then why not your continuance be considered as a wrongful occupation? And then the definition of the mean profit under the CPC is defined, I think. Section 2, subsection 12, if I am not wrong.
But 2013 onwards, even the Act, my lord, as I had stated while making my submissions, my lord, which led to the order dated 10/12, 2013 onwards, I have no right to continue. Whereas, in terms of the Caltech Act, everything ends with 2013.
No, I am asking that is between you and the other entity, but so far as a landlord, it is something different. That's why I referred to you all those judgments.
Lord, this was nationalization of petroleum sector.
I am again saying that's why there are two aspects. Voluntary and involuntary. If it is perceived to be an involuntary transfer, some protections. But your status does not get elevated. But it is considered to be a voluntary act. Then your status is more deteriorating than others. What is that judgment? I think gramophone or something judgment is there on a merger.
2013 onwards, my lord, even in terms of the Caltech Act, my lord, there is no right in law to continue. Therefore,
Why you will not pay the market rent of which was prevalent there in 2020?
kindly,
And now has to be varied in the by passage of time because it has increased manifold.
Kindly see, the order dated 22/2/22. May I just place that order? Lordship will get,
That is my brother placed it.
22, the Lordship was referring to 25. I'm referring to the 2022 order. 22/2/22, the prayer in the present writ petition is for declaring illegal the continuation of HPCL in the premises of the petitioner pursuant to a lease, which according to the petitioner was being renewed in perpetual exercise of the powers under sections 5 and 7 of the Caltech's acquisition of shares of Caltech's Oil Refining India Limited of the undertakings in India of Caltech's Act 17 of 1997. The consequential prayer is for eviction of HPCL from the premises. There is no such prayer in the writ petition. I will place that.
Why you did
petition-
not challenge this order by going higher up? If you are so much, I would say vocal on this issue,
No,
then
please
you
for-
ought to.
place the order. Come to you. I'll address what your lordship's query is. Although the petition has been pending in this court for about 18 years and notice was issued way back in 2000, etc., etc. Kindly come to paragraph 3. At the outset, Mr. Sonso, learned counsel appearing for HPCL, drew the attention of the court to the Repealing and Amending Act passed by the Parliament on 6th May 2016, whereas among the several enactments that stood repealed is the aforementioned enactment of 1977. Paragraph 3. Mr. General and counsel for the petitioner, on the other hand, relied on the judgment of Srimati Dolly Das and HPCL versus Srimati Dolly Das and the
Para 5. Come to para 5.
Acts. That period obviously came to an end on 31/10/2013. Nothing has been placed on record to indicate that HPCL exercised its right to continue in the lease beyond the appropriate period. Mr. So-and-so said he will take instructions. The repeal of the 1977 Act would mean HPCL can no longer exercise its right thereunder to renew the lease if it has not exercised any such right after 31/10/2013. Even on its own showing, it cannot continue on the premises. On the question whether HPCL has been paying market rent as directed by the Supreme Court in the aforesaid cases, Mr. So-and-so said he will take instructions. Pursuant thereto, my lord, I placed on record wherein I had requested the petitioner to renew the agreement. Lordship will take that document for a moment. It is filed on your lordship's record.
But 10/12/2025,
Now, I'm coming to that. My lord,
you have submitted before the court, which is recorded at para 2.
my lord, I'll come to
10/12.
kindly.
You have admitted
Kindly,
that
Cannot
you have no right to
order
occupy the land.
Enter order, not if you not to tell.
Please,
please come to the next order.
you
I will
have
come to-
again submitted before this court.
I will come to 25 order. My lord, kindly come to order dated 14/3. Please, lordship will kindly take order dated 14/3, order number 70. Lordship has that, my lord? A written note has been submitted by Mr. So-and-so, counsel for HPCL. As regard HPCL expressing its willingness to continue in the lease beyond 31/10/2013, he produces a letter dated 10/2/2014 addressed to the legal heirs of the petitioner. As regards the payment of market rent, the petitioner states that HPCL has been paying the rent as per the last lease deed and the legal heirs have been accepting the rent. However, it is plain that HPCL has not been paying the market rent as contemplated in the judgment such and such. Consequently, the court tentatively fixes the rent to be paid at 20,000 per month from 1st November 2013 onwards till date, and the amount so calculated will be brought to this court by way of a demand draft in favor of the petitioners on the next date to be handed over to the learned counsel, subject to the compliance with the direction. The court will be willing to consider sending the parties to make negotiation. Now,
That
kindly
is way
come to
back.
the next.
That is
kindly
way
come to
back
the
in
next.
2022.
Next minute,
Kindly
it
come
is
to the
very
next
clear.
one.
Next minute, next. It
Kindly-
is made clear that the
please, just
payment
to-
of the above
yes.
amount is without prejudice to the rights of the petitioner.
Now kindly see order dated 5/5/2022. Pursuant to the order dated 14th March 2022, HPCL OP number 2 and 3 has filed a memo pointing out they have prepared two demand drafts, one in favor of each of the two petitioners, amounting to rupees such and such less TDS. Total amount is such and such. The two demand drafts have been handed over to the learned counsel for the petitioners in court today and have been accepted by him. This is without prejudice to the rights of the parties. HPCL has expressed its willingness to extend and renew the lease agreement. Parties are willing to negotiate the terms through discussion. Learned counsel for the parties state they will negotiate to arrive at an amicable settlement regarding the terms of continuation of the lease. And thereafter, Milord, from 2022, the discussions went on, Milord. It was referred in 2025 for mediation. Mediation also failed. The mediation is reported before your lordship. Fairly speaking, Milord, two documents have been filed and those are in the midst of negotiation. So I have claimed privilege on both the documents and the rates mentioned therein. Two documents have been filed.
They can't rely on any document which was surfaced during the mediation
Milord,
as a piece of evidence. We will discard it and will direct this document to be taken off the record.
these are the only two documents they have filed for the purposes of enhancement of rent, which is not even prayed for.
I am not asking, I am just simply asking something which is detrimental to your interests that will not be taken into account. But suppose if there is some piece of evidence they can definitely lead those documents as an evidence.
Now,
Please, sir.
this went on till 2025, and in 2025, on 10/12/2025, on instructions I stated that we shall vacate the premise. That led to.
So once there is a judicial recognition that you are there unauthorizedly from 2013 onwards, there may not be any direction for vacation, but definitely we can direct the quantum to be ascertained while passing an order directing you to vacate within a time frame.
Look,
We can do it. We can do it.
Most respectfully, Millard, Order 20 provisions will apply in a civil suit where there is an inquiry for mean profits, Millard. Here there is no document and record. It's not even prayed for before your lordship. I am very fairly stating, Millard, that 30th June your lordship expressed.
I'm again saying I am not at all, I think, contemplating that the Order 20 Rule 12 can be exercised, but I say the principles akin thereto can definitely be applied in a writ petition.
Millard, that is what fell, Millard, for the contention of the Honorable High Court of Calcutta, Millard, very recently. And Millard, Dolly Das and National Company both were cited before the Honorable High Court of Calcutta. 2 writ petitions, Millard. Shipra Ghosh held that writ petition is maintainable, and another matter, Millard, arising of Delight Gray Nirman said that mean profits would be given. The division bench overturned both the judgments, Millard. I'll submit the judgments for your lordship's kind consideration. Matter was carried to the Supreme Court also, wherein, Millard, the landlord made an offer that I'll forego the mean profit. Please let them stick to a date of eviction and let them undertake to vacate on that date, Millard. For your lordship's kind consideration, Millard, I'll give the 3 judgments, Millard, and all these 3 judgments.
These are not binding on us. Maybe a persuasive value, but may not be binding
My
on us.
humble contention is both these judgments consider Dolly Das and National Company, which is the sheet anchor of the submissions of the petitioners, Millard. Identically in this case, Millard, there is neither a prayer for mean profit, disputed questions of fact arise in a 226, Millard. I am not arguing here.
Such other or further order as your lordship may deem fit and proper.
Very well, Millard. But there should be some material available and
That
inquiry.
is by virtue of a affidavit.
This has been going on, Millard. Each date, Millard, and Millard, the negotiations failed not because of Hindustan Petroleum. The negotiations failed because of the other opposite party, wherein there is a fight within the family, and I am being sandwiched. I would most respectfully submit, Millard. Kindly
Do one thing. Let them fight amongst themselves. You hand over the position now.
31.
We will appoint a special officer. The special officer will retain the position. Let them fight. It will retain. The moment the fight is over, the court will hand over to whoever is entitled. But it will be retained by a special officer.
Lordship, may appoint a receiver, Millard. 31-3, I will hand over, Millard. I have no issue. I have no problem. Lordship, may appoint a court officer to take over the premises of 31-3. I am not in the way. 31-3 shall be stuck. But I have certain statutory compliances. Because it's Hindustan Petroleum, GST surrender has to be done, and most importantly, the explosive license has to be surrendered.
What we have to do about these principles, though they do not strictly apply, again you will say in a civil proceeding, is a writ proceeding, you are trying to make a distinction in between 2. But the only distinction one can be seen that one is, so far as the civil rights are concerned, it is to be decided on the basis of oral evidence to be adduced and a documentary evidence. Writ petitions are decided on the basis of affidavit evidence. This is not a complex question. The complexity cannot be raised in the writ. In a contractual matter, you are aware from ABL International till the others, when the court finds in a contractual field that there is no complexity to be attached to it, the court can definitely see you are an authority within the meaning of Article 12. There is no difficulty. So once it is there, then in that event, why the parties would be relegated? Is it not your statutory or a contractual obligation to hand over? Both.
It is.
Not only contractual, but it's a statutory. Because of Section 108 of the Transfer of Property Act.
It is, Millard.
What is your obligations of a lessor under Section 108 of the Transfer of Property Act? Look at it. Is an obligation to hand over. There are two obligations under section 108.
Hello.
One is of a lessee, another is of a lessor. What is the obligation of a lessee? I think J or K, whatever. To hand over possession.
108 subsection 5 says on determination of the lease.
I do not know. Subsection 5 is there. 108, I don't know.
There is no subsection.
I do not know. That's why I'm just reminding it. I do not know whether subsection 5 is there. I think the clause J or K of the lessee's obligation.
B says the lessor is bound to, on the lessee's request, to put him in possession of the property. That is B.
No, that is the lessor's obligation
Yes.
heading.
Yes.
I'm talking about lessee's obligation. Turn the page. Caption is, heading is lessee's obligation.
Lordship is right.
Please. I think J or K, whatever.
Hello.
My memory is now betraying me a little bit.
The lessee is bound to keep on the termination of the lease to restore the property in as good condition as it was at the time when he was put in possession, subject to reasonable variance.
What is that clause?
That is M. M. The lessee is bound to pay or tender at the proper time the premium of rent to the lessor or his agent.
Is it not your statutory obligation to hand over the possession?
It is.
Why you did not in 2013?
Because negotiations have been going on up to October.
Does it mean that you will? Does it mean that you will continue?
There was a running petrol pump.
There's a running.
They came for
Then
the negotiation.
section 114, you cannot claim a holding over also.
I'm not claiming a holding.
You
I'm not
can't.
claiming a holding.
114
I'm not claiming a holding.
or 16, I do not know.
Hello.
Nowadays, 116 probably.
Hello. Effect of holding. I'm not claiming a holding.
He has not assent of continuing in possession. That is the language of holding on.
Hello. The
Once.
negotiations are on as late as October 2025.
And what about section 111?
Failure of the negotiation.
111?
It says that no, we
111 of the TP Act. Only one line.
One line.
Lease determines
Yes.
A.
Yeah.
What is this? A.
Is by flux of time.
Is it not expiry by flux of time?
Well, then I would take your lordship to 106, which says it is month to month. There.
106 is a notice. You are talking about is a notice. If it is agricultural purposes, then the period of notice is more.
6 months.
If it is otherwise, then the period of notice is 15 months or a 1 month. I think 15 days have been now substituted.
Yes. It shall be deemed to be a lease from month to month, terminable on the part of the lessor by 15 days. 15 days is sufficient.
I'm giving you that. So it's a notice of termination by giving a 15 days time. What more? You have exceeded 15 days.
No notice. Can we see the prayer?
And does
There is
it
no
does
notice.
it does it sir,
There is no
again,
notice.
you have entered into a very difficult domain.
I'm learning.
In case of section 118, in case of section 111A, is notice under section 106 mandatory? No notice is required to be issued under section 106 if the lease expires by flux of time. No manner of application.
But may I take your lordship to in 111H on the expiration of a notice to determine the lease or to quit?
That is another. That is one of the instances of 111.
Yes.
I know. There is an instance of forfeiture.
Yes.
Forfeiture requires a notice.
Yes.
But by flux of time, the language is a lease determines by a flux of time. I think first sentence of 111.
Yes, determines by a flux of time limited thereby.
Correct.
That means
So once the time goes out, no notice is
The
required.
time should be prescribed. There is a situation whereby by the statute it was till 2013. Now, if your lordship stretches it to say by statute what is prescribed.
Is there any statute which says that the contract between the parties will automatically get extended
So it says I have the
Beyond.
right, section 7 of the Caltex Act, it says I have the right to exercise, which I did exercise,
What exercise?
to extend a lease of a petrol pump.
Is it a one-way traffic or it is a reciprocal
Therefore,
obligation?
this writ petition has this prayer, my lord. Kindly see page 16, which is the prayer. Please see the prayer for a moment. Writ is filed in 2004. Please see the prayer for a moment. The petitioner therefore most humbly pray that your lordship may be graciously pleased to pass an order declaring that the OP number 2 has no right under section 5 and 7 of the Act to claim any renewal of the lease in respect of the disputed land after 31/10/19.
So it's a renewal.
Yes, issue a writ of certiorari or writ of direction in the nature of certiorari, quashing annexure 5, 8, and 14, and to grant such further relief as may be deemed fit and proper. That's the only limited prayer.
Correct.
Quash
So-
the annexures.
So renewal is not automatic.
No,
My lord, may I finish?
please permit me.
I have filed 2 miscases, praying for amendment on the prayer, and those have been allowed. I have prayed 5,000 during those difficulties. Or 50,000. Notices are there, with petition. Agree?
Well, this is beyond the record. That's beyond that. It's nowhere on the record. Nowhere on the record. My respectful submission.
Again, I'm saying,
Quieter-
show us that the renewal and extension are one and the same.
In this case, Vinod, it would not be a renewal and extension in terms of civil law or transfer of property act.
No.
It was the Caltex Act which gave me the right.
Can it automatically renew the contract between the parties?
No,
I
it's
think
okay.
no law as of now, I have not come across, pardon my impertinence, pardon my ignorance. I have not come across any law which says that the contract between the parties will automatically get extended beyond the period of a contract.
Well, the Caltex Act was also challenged. So
Please, I do not know whether it can, contractual obligations
No.
with a third party who has no role to play in a Caltrex. I may be wrong. I'm ready to admit my wrong perception, provided you just show me that yes, it can be done.
This plays the provisions of the Act.
Please.
Probably, I would be able to persuade your lordship. And this Act was challenged, and sustained.
That's true. Virus of the act is challenged. It is said intra-virus, not ultra-virus. We are not on that issue. The constitutionality of an act is not an issue here.
No.
We are not going into that. But I am really wondering whether it can. A lease has a limited duration. By virtue of this, that duration will be automatically extended. I just wanted to know these principles.
My sheet anchor is the Caltex Act, which enabled the renewal.
Whatever,
And section-
there's again, I'm saying, there is a concept of a renewal, a different concept of a renewal, and a different concept of a extension of a time period. I believe when two words are used, both have a distinct meaning.
They do. I'll just place the Caltex Act for a moment.
Yes.
It's on your lordship's record already.
Oh, difficult, sir. Difficult, sir.
Well,
No,
that for me
it's difficult.
It's a Herculean task.
No, I'm just reminding you again, you go and read the judgment of Delhi Municipal Corporation or Delhi Development Authority case, probably in 1973, Supreme Court, and the subsequent judgment of Provas Chandra Doloi, Provash, where the Supreme Court has very clearly and succinctly made a distinction between a renewal and extension. Renewal is a different concept than the extension.
Following that judgment also we have, you dictated and we have done it.
Chapter 3 of the Caltex Acquisition of Shares of Caltex Undertaking Act says,
Yes. Acquisition of share of whom?
that is Caltex acquisition of shares of Caltex Oil Refining India Limited and of
Correct. So that is a separate entity. legal entity, I believe.
Yes.
You obtained the share.
No, that was the company which had signed the original lease.
Oh, please try to understand. Your relation is with a third party.
Yes.
Now, this statute talks about the acquisition of the share of that company. That company may have merged into a CL. That is an internal mechanism between the lessee and the third party. But once the third party comes vis-a-vis the landlord, what is his status? I'm asking.
But Section 7, subsection 3 deals with that.
Please read it with the third party.
Section 7 starts with subsection 1. Every right or interest in respect of any property in India, including a right under any lease or under any right of any tenancy or any right
Shall stand west into a CL.
under any arrangement
True.
to secure any premise for any premises
Correct.
where Caltex India held immediately before the appointed day
True.
shall, notwithstanding anything contained in any other law or any agreement or instrument relating to such interest, right or interest,
Right.
rest in and be held by the central government on and after the appointed day on the same terms and conditions on which Caltex India would have held.
So is a substitution of a new entity in the shoes of a Caltex India.
Well,
So does it change the status?
can you permit me to go a little ahead?
Little ahead.
If no negotiations had taken place for the acquisition by the central government of the undertakings of Caltex India, or as the case may be, if this act had not been passed. Subsection 2. If at any time after 2nd February 1974, being the date on which the central government policy for acquiring undertakings engaged in the production, marketing or distribution of petroleum products was made known, and before the commencement of this act, Caltex India surrendered or otherwise relinquished any right or interest in respect of any property in India, including a right under any lease or under any right of tenancy or a right under any arrangement to secure any premises for any purpose, then for the purposes of this act, notwithstanding anything contained in any other law or in any agreement or instrument relating to such right or interest, the central government shall, on or after the appointed date, be entitled to such right or interest on the same terms and conditions on which Caltex India would have been entitled to such right or interest if it had not surrendered or otherwise relinquished such right or interest.
So
and
what
this
does
act
it
is not
mean?
passed.
What does
There's
it
more,
mean?
there is more.
More.
Provided that nothing in this subsection shall apply to any right or interest surrendered or otherwise relinquished by Caltex India before the commencement of the act or satisfied for sufficient monetary consideration. Now, subsection 3, which is relevant. On the expiry of the term of any lease, tenancy, or arrangement referred to in subsection 1 or subsection 2, such lease or tenancy or arrangement shall, if so desired by the central government, be renewed or continued so far as may be on the same terms and conditions on which the lease or tenancy or arrangement was originally granted or entered into. The first right of renewal was exercised. The second right of
No,
renewal
please
was
read
exercised.
read again.
On the expiry of the term of any lease, tenancy, or arrangement referred to in subsection 1 or subsection 2, such lease or tenancy or arrangement shall, if so desired by the central government, be renewed or continued so far as may be on the same terms and conditions on which the lease or tenancy or arrangement was originally granted or entered into.
That means what? It is an option of the central government to exercise, which cannot be said to be a one-way traffic. It all depends upon the other's consent to the continuance. It says that once the term has gone, if the central government so desire, it may continue on the same terms and conditions after that. That all depends upon the consent of a landlord in permitting you to continue these applications.
I would
It never says that if so desired, it says that never says that it really impinges their right. It will be opposed to a rule of perpetuity.
All this ended in 2013. Therefore, the date of 1st November 2013.
Whatever be, continuance without the consent of a landlord is very, very dangerous proposition. God.
I'm just reading the act and placing the act.
No, the act does not really say what the purpose of the act has to be understood. There are two the object which is laudable or a message which is laudable from section 7.
No.
One is that if they step into the shoes, they will continue.
Yes.
Second says, in the event the outgoing company has already relinquished or surrendered his right of a lease or a contract or whatever in the property,
For money.
then sorry, that will again be revived,
Right.
and the central government will continue under this
That-
on the same terms and conditions. That means the act of relinquishment will get evaporated or eclipsed by virtue of the operation of the law
Yes.
because of the misfeasance done by the erstwhile going company.
Yes.
The second aspect is that if it is done for some kind of a premium or a monetary considerations, which is reflected into the accounts of the outgoing company, then in that event, it is open to the central government whether to accept or not to go.
Yes.
This is up to this. Third one says that if it has already expired or is going to expire, it is open to the central government, if so desire, can continue on the same terms and conditions. That is always because you are not using it in that sense. There is a privity of contract. By virtue of a statutory document, you cannot extend the operation of contractual obligations beyond the term which the parties intended. It will be, I would say, the fallacious thing one can understand on that. Cannot be done. So if they have not permitted you to remain, admittedly you are in possession. It does not mean by operation of the law you can continue there for all time to come. Impossible. If you say, I will yield, rather subject to my brother concurring on that, is against the very, very basic tenet of a law of a contract or a law of landlord and tenant. Impossible. Difficult task.
Not till 93, the leases
Oh.
we continue. Post 93, the central government exercised its right under Section 7, and we have continued till 2013. Now we are talking about my respectful submission.
You can't, if the period expires from that day itself, you are without any right. You can't continue by virtue of operation of the law.
So that has been sustained by the Supreme Court in a series of cases.
So that is what is the why. Only thing is, provided the period is still continuing.
But the period was continuing, not 93 when it ended.
When it ended, you say 1960 something, the lease is.
On 1/10/74, the lease was renewed. And the lease was renewed
Up to 93.
till 93.
So after 93, what is your?
93, in exercise of the rights the central government exercised under this act, till 2013, and post 2013, no rights subsidy. Therefore, I made this submission.
What is the right central government exercise 7.3,
Come back to
which you just read?
No.
7.3.
No.
Yes, we will interpret 7.3.
But that has already been interpreted by the Supreme Court. There's no
What?
SNC grant.
What? Show us that the Supreme Court.
It's on your lordship record.
Yes, show us that what the Supreme Court has says that it can,
That the central
and that absolves the responsibility of. Just show us. Let me see what it held.
Kindly take section 7 again of the
No.
No, let me place the Caltex Act. What's exactly?
No, 7.3 you have read.
No,
I
on the expiry of the term of
correct. I know. Where is that judgment of Dolly? Let me understand.
There on the lordship record.
Yes. No. This is this High Court.
Yes,
Now this
I am talking about Supreme Court.
Then
this arose from this High Court. This
Where is the Supreme Court judgment?
1994 4 SCC 450. It was filed before your lordship.
Yes, 1999, volume 4.
4 SCC 450.
Yes, please. Yes, I'm just reading.
renewal of lease could only be for one term and no more. But that is heading paragraph 12.
Have you seen this judgment? Thanks for inviting my attention. I think the apex court was very much conscious. And then it is Article 142, which was exercised ultimately for complete justice. There was nothing which can be decided. The court has been very categorical on this, that what is the effect of the renewal. And it does not talk about that it is 7.3 has a paramount of the applicability over the contractual rights. Definitely not.
May I place paragraph 12?
So that is what it says.
May I place paragraph?
Please read carefully. I have read up to paragraph 13. I have gone.
No, I'm applying. The lease has been granted with effect from 1/10.
It was paragraph 12 is the last.
Last part. This is the finding of the court. In favor of Messrs. Caltex India on coming in effect of the Act on 23/4/1977. In the facts of this case,
Sir, the reference was something different. It was a lease which was there earlier in 1969 or a 70.
Miller.
It had a clause 3 small g, which permits the lessee to exercise an option for renewal of the lease for 10 years at an enhanced lease rent with another stipulation which was very important, containing a further right of renewal of 10 years. So it is the first option for renewal which is exercised, which will give a right to have the renewal for 10 years with the clause for renewal of another 10 years
Yes.
at a further enhanced rent of 1920 or 1920 or something.
Place paragraph 12.
Then the court says that yes, 7.3 does not give an independent right. It only gives, if you so desire, you can have the renewal once.
Yes.
And there the court says that you have already exercised 2 in terms of clause 3G.
Please permit me to place paragraph 12. Kindly. Most
No,
respectfully.
no,
Please permit me
no.
paragraph-
Before that, you read many paragraphs.
Yes, yes.
Then I am reading for you to understand what really goes. I think you should start from paragraph 10.
From paragraph 10. Paragraph 10.
Others are a basic demo, point of demo.
Well, now we shall turn to the merits of the case. The merits of the case as to the extent of the period of renewal will entirely depend on the interpretation of clause 3.
Then what we gather?
No.
That it is as per clause 3. That is means the part of a contract. Now read.
Identical in this case as page
Sir,
21.
sir.
Same, the contract is the same.
Come.
Identical here. Page
I am
21.
coming. Then read.
The
They
merits
talks
of
about
the
a
case-
contractual right.
As to the extent of the period of renewal was entirely dependent on the interpretation of clause 3G of the lease deed.
Correct.
Clause 3G of the lease deed provided as under that the lessor shall, upon the written request by the lessee before the expiry of the term hereby created, grant to it a lease of the demised premises for a further period of 10 years from the expiration of the term granted at a monthly rent of so and so, and containing the like covenants and provisos as are herein contained.
So is a first option for renewal.
Yes.
Then
And clause 3G at page 21.
no, including a clause for one renewal.
Clause 3G in this brief is also identical. It's the same.
Oh, sir, please come and read
Yes.
the clause 3G.
Yes.
For a further term of 10 years.
Thereby granted at a monthly rent of such and such, and containing the like covenants and provisos as are herein contained, including a clause for one renewal for a further term.
So what it talks about?
One renewal.
One renewal
10 years.
with a clause of further renewal.
Yes.
That is what it says. Yes.
And on the same terms and conditions as herein contained, as to get the lessee.
No, rent is also indicated that at the enhanced rent.
At a monthly rent of 1920.
Correct. It was first renewal was 1720.
Yes.
Second renewal 1920.
Right.
Keep in mind, I'm just harping on that.
This record is
No, no.
exactly what has happened.
Oh, just keep. Then I will tell you to understand. I will make you to understand. Just hammering, as you say. Please note, my lord, note this point. I am also saying note these 2 points.
2013.
Please come. Read.
And on the same terms and conditions, terms to conditions as herein contained, so as to get the lessee at its option an aggregate of 2 renewals, each of 10 years. Upon such exercise of right of renewal, a fresh lease incorporating all the terms and conditions with clause G suitably modified on each renewal or deleted in case of last renewal shall be executed and registered by both the parties to these present. The High Court took the view that in the absence of a deed of lease, clause 3G in the original lease deed had not been acted upon by the appellant, though the appellant had exercised its option by letter dated 23/5/79. The learned counsel for the appellant submitted that this view of the High Court cannot be supported at all if we read clause 3G in a fair way. According to him, there are 2 components in clause 3G of the lease deed. The first of which binds the lessor is imperative terms to renew the lease for a period of 10 years from the expiration of the term at a monthly rent of 1720 per month on the same terms as contained in the original lease, with a further power of renewal for another 10 years at a monthly rent of 1920 on the same terms and other conditions as contained in the original lease. Thus, it is submitted that the option given to the lessee is an aggregate of 2 renewals each of 10 years. The second component of the said clause, it is submitted, is as to the execution of a fresh lease incorporating the terms and conditions with clause 3G suitably modified on each renewal or deleted in case of the last renewal and shall be executed and registered by both the parties to these present. He further contended that the second component, though requires to be fulfilled, does not take away the right of the lessee to renew the lease, and therefore he submitted that the view taken by the High Court is fallacious. He further submitted that when the original lease deed itself contemplated renewal, even if a lease deed has not been executed, does not by itself defeat the option for renewal. On the other hand, she also submitted that a covenant for renewal contained in the lease does not ipso facto extend the term of the lease, but only
tenure or the term of the lease, both.
Extend the tenure or the term of the lease, but only entitles the lessee to obtain a fresh lease in accordance with and in due satisfaction of the law governing the making of leases. He submitted that the terms in the agreement provide for renewal of the lease on certain conditions, and renewal could not be obtained in piecemeal and in violation of any part and portion. And when an option is exercised under the said law, the entire provisions of the same must be followed and complied with. In the present case, the claim for renewal of the lease was not followed up by a deed, and therefore the lease had not been actually renewed. He submitted that mere sending a letter for renewal of lease would not create a lease to allow renewal of the same. The clause requiring the execution of the lease deed, incorporating the terms and conditions, is the condition which needs to be fulfilled when the option for renewal is acted upon. He further submitted that the view taken by the High Court is perfectly in order.
Yes.
The lease had been granted with effect from 1/10/1969 in favor of Caltex India, and on the coming into force of the Act on 23/4/1977, the appellant had stepped into its shoes, and from that day onwards, the appellant has been in possession of the same till now. The crucial question, whether the option for renewal, either in terms of the lease deed or in terms of the Act, have been availed of or not, is the controversy between the parties now. Litigation between the parties has been going on from 1993 onwards. On the expiry of the lease, the deed provides
on the expiry of a term.
On the expiry of the term, the deed provides for renewal for 2 terms of 10 years each on the same terms and conditions, except for enhancement of rent and execution of fresh deed modifying the clause relating to renewal. The appellant gave notice of renewal in terms of the provisions of the deed in the letter dated 23/5/1979 and the act in the letter dated 13/9/1989. Now it is not necessary to examine the effect of renewal of the earlier period, as even on the appellant's own showing, it is invoking the statute in the latter notice and not the terms of the deed. If that is so, the appellant would seek for renewal only in terms of Section 7 of the Act, which enabled it to renew the deed for a period of 1 term as originally granted. A covenant for renewal is not treated as a part of the terms prescribing the period of the lease, but only entitles a lease to lessee.
The-
I'll reread that part.
Please, section 7 of the act which
Milord, I'll
enabled.
reread that part. Now it is necessary to examine, Milord, I'm in paragraph 12 in the middle, Milord.
No,
Now
no, if that is so,
Now,
the appellant, you
Now it is
read.
necessary to examine the effect of renewal for the earlier period, as even on the appellant's own showing, it is invoking the statute in the latter notice and not the terms of the deed. If
Yes.
that is so, the appellant could seek for renewal only in terms of section 7 of the act, which enabled it to renew the deed for a period of 1 term as originally granted.
Yes.
A covenant for renewal is not treated as a part of the terms prescribing the period of the lease, but only entitles a lessee to obtain a fresh lease. Renewal of lease could only be for 1 term and no more. But nevertheless, it could be contended that the covenant for renewal was also part of the lease and therefore stood incorporated in the reduced lease arising under the act. However, in the peculiar facts of this case, we think it is not necessary to enter upon the merits of the controversy regarding the effect of clause 3G of the lease deed or the rights available under the act for
So
renewal
this
of
is
lease.
kept open. That is what I really wanted to harp on it.
Milord,
The
may I
court
place
may
May I please permit me to go ahead?
please.
We are of the opinion that the
Yes.
ends of justice in this case.
That is Article 142.
Yes, if Milord,
Sir,
236 Milord.
what are you talking? Supreme Court Article 142 applying, not 141.
Milord, if we modify the order of the High Court.
So
to the
that means
terms,
for the ends of justice, because the court did not decide that what would be the effect of the clause of renewal and the act vis-a-vis each other, says open. I feel, the court feels that I think it will subserve the complete justice. Modified the order, Article 142.
Milord, probably Milord, in the mind of the court, the efflux of time.
No,
And
sir. No, sir. Otherwise, this sentence, that is what I really wanted to harp on that.
But then your lordship would like to give a finding on section 7 Milord, and the interpretation.
And that is what I'm saying, that there are series of judgments on that which does not really come in the aid.
Milord, but in my
It all, yes, renewal always postulates reciprocal decisions.
No, but if your lordship takes the last paragraph, the applicant does not have the power to claim exercise of the option for any renewal of the lease beyond 30/9/1999. So first renewal they recognize. The appellant seeks.
1999?
93 after 93.
99, Milord. Let me see the language, Milord. Up to 93, I had a lease. So I have exercised my right, and the lease term is 20 years. 3G, 93 plus 20, 2013. That is my respectful submission. Hence, Milord, I made this conscious submission that post 1/11/2013, the law does not permit me to, and that is, Milord, I stated.
So till now you have
that is correct.
No,
because
post 11, 2013, what is this?
2013 onwards.
That is a judgment. This is I do not know. That is how it talks about this.
Now, Milord, kindly see what it says in the last 5 lines of the judgment. The appellant seeks for and is granted time to hand over vacant possession of the premises in question to the respondent on or before 31/3/2000. However, subject to filing of the usual undertaking in this court within a period of 4 weeks.
Sir, what is there? 1969 lease was for a period of 10 years.
Yes.
3G says that it can be renewed for two times
Yes.
of a like tenure or a period. So if 1969 is taken as a starting point of a limit, the lease, operation of the lease, 10 years expires in 79. That's the original term. First option of renewal from 79 to 89, and the second option of renewal from 89 to 99. That is why the court has said that you could not claim any renewal beyond 30th of September
I
1990.
fully bow down to that. Now, kindly see the facts of the present case. The lease is entered into on 21/11/1963, 10 years. Lease is renewed.
73 gone.
Please permit me to place.
Let us see, 10 years or 20 years?
That first lease, 10 years.
10 years. So 73.
74, 10/10/74 lease is renewed. 20 years.
Please, I am coming.
That is the effect
Then
of the
please. It is renewed. it is renewed,
Right.
then it is renewed for 10 years more.
No, my lord, renewed for 20 years. That is the
Okay, 20
distinct-
years. Okay, no difficulty. So 63 was the first lease.
63, 10.
Then 73. And from 73, 20 years is 93.
And then, my lord, I exercise section 7, which gives
Was
20.
there a clause of this nature that second renewal is also permissible?
Clause 3G, my lord, identical.
No. In this present
Yes,
lease.
same, identical, same. These are, my lord, common leases across the country.
Oh,
Identical.
please. Does it contain a 2 times renewal?
Lord, 63, 10 years, no dispute. 74 effective, 73, 20 years, no dispute. In the meantime comes the Caltex Act. In exercise of my rights under the Caltex Act,
I am
93
asking.
plus 20, 2030.
I am asking. I will decide. No doubt about it. I will decide that aspect.
Well,
I am simply asking what is the object. Does it contain another clause of 10 years?
No, it is 10, 20, and then renewal.
Please, 3G says then 3G is 10, 10, 10, 30 years.
No, that was changed in this agreement.
That is what I wanted. You are,
Change in-
Mr. Counsel, you are a responsible member of the bar.
They agree to 20.
Please, I wanted to know where is a clause for renewal. You are saying it is an identical one. Identical, then 10, 10 and 10. But if you get a 20, then one has to understand that what is the meaning of 20.
20 cannot be read as 10, my lord, in my respectful.
Oh, then one has to read 20 in what sense? It is a 10 plus 10 or it is a 20 is a individual?
20. Please see the terms of the lease. It's on record. The first lease 3G is 10 years. Then it says 20 years, and that happened before the Caltex Act. The Caltex Act came in 77.
Does it contain a second renewal?
The second renewal is in terms of the Act, my lord. Section
Sir,
7.
3G, I am asking when you are referring this judgment of Dolly Das, there is a 2 times renewal provided in the lease deed itself.
Dolly Das is being relied on by the petitioner. That
I am saying there were two times the renewal was there. When the reliance is placed,
Yes.
I'm simply talking about Dolly Das does not talk about what is the effect of 7.3. Silent.
Subsequent judgment. Madras High Court. Madras High. Relied on this subsequent judgment of 2021 Supreme Court.
Hello?
National.
National is relied on by the petitioner. And my lord, subsequent thereto in 2023, as I was submitting, my lord,
There Dolidas, which is referred to, I think, in Madras. Madras High
there the
Court.
distinction is, my lord, that was
So
under the.
their lordships have
tenancy.
brought out that distinction 148, 141,
My lord,
Article 141.
yes.
And as my lord has said, this Dolidas is under Article 142 and under that peculiar facts that is decided.
You know, then I would most respectfully submit that he must not have a case. If Dolidas is not being relied upon and national.
Sir,
company-
he has a case on the basis of the facts.
Well, then the writ jurisdiction will not most respectfully
Definitely, that is what
Attack.
the principles of law has also been decided in Dolidas by the Supreme Court, which is Article 141 observation.
Once it is exercised, discretion is
It
exercised.
says in paragraph, it has been exercised, then you cannot wriggle out of it.
Well, my respectful submission.
Sorry,
till
we can't.
2013, I am
And-
protected by the Caltex Act.
No, that I will say that what is the protection and to what extent your protection
And
is there.
section 7, my lord, I can exercise the renewal once I have exercised. the
This is what also was kept open in a Dolidas.
Well,
Court did not observe.
period.
The court simply said, since he exercises both the second renewal and the act only talks about one renewal, which has already been exhausted, nothing more can be done. And it ends abruptly and say, I am not going to decide this.
Because of the statement.
And there are many judgments which followed subsequently. And there are many judgments which preceded to that judgment has not been cited by the counsels there. Of a Supreme Court of a larger quorum.
And the latest is this one, wherein their lordships were considering an identical situation from the Calcutta High Court. Don't. This was again relying on Dolidas,
But there is no discussion about this. aspect. Article 142. Was there any discussion or argument?
Of the Calcutta High Court which led to this. Judgment of the Calcutta High Court on mean profits. This is on mean profits. And Shipra Ghosh, my lord, was on the maintainability under 226, my lord. Two 26 was the single bench held maintainable.
Article 142.
Yes, everywhere it is. Shipra Ghosh, first the single bench held maintainable, division bench overturned it. Profit, single bench held.
That is Article 142,
mean
that's
profit,
right.
would be
That's
payable in a writ jurisdiction. Division bench overturned it, and finally, when it went to the apex court said, if the landlord is willing to forego the mean profit, which day will you vacate? And we vacated.
Oh, that is a different aspect where they agreed. Here it is not, they are not agreeing. What to do?
There was also a case where they didn't agree and statutory powers under 7 were exercised. Renewal was available. Here, if your lordship wants, I'll place a short note with the relevant provision.
You are dictating it. Don't worry about it.
We will not.
The law of the tenancy, the law of a lease, everything will dictate. In conjunction with the section 7.3. Don't worry, of the Caltrex.
But my respectful submission would be 31.3 we will vacate. Your lordship will not mean profit if your lordship wants to get into it, but anything reasonable which your lordship thinks appropriate. There is no material on record, we'll bow down to that. But 31.3 we shall vacate. That I shall ensure.
Once you have consumed so much of time, then we will definitely decide the proposition of law. In order to set at rest what has been argued now. Have you got that Chaundi Moppet's case?
Yes.
I'll file a written note, Lordship gives me.
What is the reference?
I'll file a written note.
Give a reference of that judgment. 95, 85. What is this?
Lordship give me 2-3 days time to file a written note.
1992 volume 3 Supreme Court cases, page 1.
Write down 1992, volume 2,
Volume 3.
volume 3, SCC page 1.
It permits like 2-3 days to file a review.
Have you found out this Provas Chundra Doloi's case? PROVAS.
The other is 1989. 1 SCC 487.
That's Chandra Dalvi. BALU. Probas, PRO,
PROVAS, I believe. VASH or VAS.
VAS.
But if you give me 2-3 days time to file it, so speak to. Is clear?
Fine. Item number 3.
Wait.
Item 3.
Yes. This petition is filed this PIL, who is a resident of the village Nota, with a written resolution from 3 GPs, 3 Gram Panchayats of the neighborhood. And Nota is a village which is centrally located in the district of Nayagarh, and it also has some centralized services provided to the villagers, like the essential public institutions like health sub-centers, post office, cooperative society, and others Vidyalaya up to class 12. Now here, in the year 2021, a notification came from the government that RI office cum residence would be established along with 17 other GPs in the village Nota. And regarding that, in the year 2022, the superintendent engineer issued first notice of tender inviting for the construction. That was in the year 2022. And in the meanwhile, from 22 to 25, a second invite of tender was also called, but in the meantime, nothing has progressed, and the villagers were waiting for the establishment of the RI office. Now, in the year 25, when a second tender notice was issued by the executive engineer, then the villagers came to know, and it was also published through a local newspaper, that the same office is not being established in Notar, although it is being established in a different village, which is in a different vicinity. The name of the village was Songhe. So here, they filed their first representation to the collector Nayagarh regarding their dispute. Now here, the Tehsildar has filed a report, which I do not have in my possession right now, that due to insufficient land in Nota, the RI office was shifted to a different village. However, there is sufficient land. I have submitted the Annexure 8 regarding that, an additional document which is in flag B and flag C, where the RI officer, the Tehsildar, all have admitted and have given the plot number and the khata number of the plot which is vacant for the RI office.
You have taken any decision on this?
But I have taken the document from the government back like this. That has been taken up next week. I will take it.
The prayer is to construct RI office in Nota.
No,
You have decided to
2020.
establish. You have decided to establish. You have decided to establish.
Yes.
I think answer
Minute that is
Annexure 1.
page 13,
Huh.
serial number 2.
Construction.
For such a long period.
Next.
Civil Services Department. Additional government.
contested litigation has been filed by the villager regarding not illegal mining and not interpretation of stone quarries without any leave. And you also will kindly see, not so since 2017-18, not so the government has stopped giving lease quarries. But the not last year they've been digging it since then. Not of that the mining officer, it will also kindly come to page 16 annexure 2. The mining officer of Baleswar writes to the mining officer Banipad regarding illegal excavation and transportation of stone from Sukhuapata hill quarry. He has said that there has been illegal mining and he has to look into the matter. The language is just may read out this. In inviting a reference to the subject cited above, I am to inform you that during routine enforcement on Sukhuapata hill quarry, we detect rampant excavation of stone illegally through blasting by some miscreants. As per the
What is the
complaint-
date? What is the date of the? What is the date of the letter?
23/9/2025 only.
What you have done?
So
You are
far-
aware of the common cause judgment of the Supreme Court.
Sir, there are two districts involved. One is Baleswar and one is Mayurbhanj.
Whatever, if
So
somebody is
Mayurbhanj-
doing an illegal mining without any permission or a grant or a license,
In
What is your
Mayurbhanj,
obligation?
We have conducted an inquiry and this is the action taking report, the mining officer has given about the prevalent situation and what are the action taken. Baleswar is concerned, I have not been able to obtain any instructions. Will permit me in the next occasion, I will get that instruction. But so far as Mayurbhanj is concerned, he has given an
and
inquiry.
we are
is conducted.
directing the police to be posted there, not to allow any kind of a.
Yes, everything has been done, and police.
Nothing has been done. Baleshwar, you have not done anything.
Baleswar, I don't have instruction.
You have realized only fine.
Fine,
Yeah,
sir,
really.
that was not
This Sukhuapata
Sukhuapata.
hill quarry, that is Mayurbhanj,
Mayurbhanj.
Kaptipada,
Mayurbhanj.
right?
This is in Mayurbhanj, Sukhuapata.
So you have realized only fine.
There are the number of machineries were confiscated, FIRs have been lodged, and squads have been constituted to be vigilant, fine and penalty have been enforced, and a number of things have been done, and I have the instruction that I received was actually voluminous, running into hundreds of pages. I can file an affidavit to that effect, but this is the long and short of it, is what I've given. In short.
What about the Baleshwar?
Baleswar, today because the president is coming, they could not give instructions. My lords may give a short time, and yes, from Baleswar.
Three vehicles only. Only 3 vehicles.
Not,
No?
that is not Mulan. That is not Mulan. That is whatever they have, they could see.
Day for yesterday, I was coming from that side. What is the number of trucks supplied towards other states?
Plus, some mines are still operating, only illegal, whatever the illegality is being done, on that they're clamping down. But some mines are operating and the operations are going on. If my lords will permit from Baleswar district, will not obtain instruction, short date.
There is a judgment of common cause.
And NGT,
So you do
NGT
not
has
come ready with
transferred.
that. Your entire case depends upon that judgment of the Supreme Court. The Constitution means decision.
Sir, NGT has taken some actions.
No, I don't know because on our report,
No, that is a different.
He can.
No, that NGT matter is a different matter. I also made a query to them. That's a different matter.
No, that is relating to this query, no? Sukhuapata.
Yes, but
What is the outcome of this? This is going on or pending or?
Here, common cause that I'm searching.
that means I have not.
In 2019, there was a stay order.
Yes, but And my lord, as of now, also, my lord, the inquiry is going on. And my lord, these proceedings are continuing. The process of, my lord, clamping down on illegalities is still ongoing, my lord.
But you can't show, you'll have to.
My lord, because the prayer in the expedition is for an inquiry to be conducted. So, my lord, that is what I was saying, my lord, so far as Mayurvaj is concerned.
Do you think that the PIL should be restricted on the basis of a prayer
No, my lord,
only?
my lord,
The court can, either suo moto, it can register the PIL and can pass the order.
power to.
So what
My
is
lord,
this
that's
happening?
sufficient
What is this happening after this judgment way back in 2017? Nothing is coming out. The reality is not there. How can you do that? And this is which one?
Sukwapata.
No, which district?
Because there is one Sukha
This
Pata
is
is
Mayurvanj-
Alpar district
Mayurvanj and Baleswar.
and Baleswar. Baleswar is, it's not Baleswar, it is not so Sarisuga.
And with regard to this blasting, second page,
Yes. This is an action taken.
the moment you seek to take instruction, this is the outcome.
This was
So see,
submitted on.
maybe
This was
informed for taking necessary action.
This was submitted in the month of October, my lord. Now, my lord, this is action taken report of October, my lord. This is not the instruction per se to my query. This, my lord, they are forwarded.
4 months is a shorter period
This,
to
my lord,
take
is
in
a-
action.
is a communication between two authorities, my lord. The mining officer has communicated this to the collector, my lord, saying that this is what we have done. So this is not instruction as per my query, my lord. My lord, this is in short, in summary, my lord, it has been written, my lord.
What to do? Immediately, the police picket should be
Yeah, in my views also, my lord, I have talked. They have also informed the police, but my lords may also pass their order, my lord. I'll be obliged.
for the time being. Huh? That we get. Despite this I do not know. That's a verbal instruction. We do not know what you have handed over. We extracted therefrom. Let the affidavit be filed by the state.
Or 5.
Already project, pipe to water supply project which was started in the year 2017. We have it has not been completed and the entire money has been paid to the contractor. And after intervention of the locality, which came to the light, my lord, that the project on question has not been completed and no water supply supplied to the villagers. My lord, 135 villages they are prepared to get water.
My lords, as per his annexure 7, page 29, a technical expert committee was formed. Thereafter, my lords, the technical expert committee, they conducted a rectification and a field verification so as to ascertain the situation. And thereafter, my lords, the LLP was requested to take such necessary steps and then file an action report. Subsequently, action report was filed by LLP. However, the authorities were not satisfied with such action report because there were several lapses and defects in the report. So they suggested that those defects be corrected. Then my lords, if my lords may come to page 35, wherein a letter
34.
34,
Yes.
wherein a letter has been sent to the country head of L&T saying that unfortunate to intimate you that most of the villages of both the blocks are deprived of getting drinking water through the aforesaid mega PWS scheme.
This is
There
going
are-
on since 2017.
Yes.
Yes, madam. So contract was executed in 2017.
So
Then thereafter.
What was the time period
2
within
years.
which it
2
is to be
years.
done? So what you have done, 2019, then?
Then, madam, after the representation was received from the petitioner, then accordingly the committee
why?
was formed.
You yourself will not monitor the.
No, madam, it was monitored. However, since the execution was.
Madam, the water
it was
is the
delayed.
essential source of life.
Yes, madam.
So how can you deprive those villagers of the water, drinking water?
Is it required? Is it required that every villager should come to you and give a representation? Then only you will activate or wake up from slumber.
No, madam, but despite.
Is it not
efforts
your
from
duty?
We have also issued show cause notice to LNP to answer as to why the execution has not been completed yet.
When?
And the
That was done when?
While as the show cause response was submitted, show cause notice was submitted on 7 January 2026. And since then, after that,
So
no response has been submitted.
Till now, from 2019 till now, you have never bothered
Yes.
whether villagers get the water or not.
And it's from 2000. As per the record, my lords, what from the instructions, what I could gather is that after the representation was sent to the governor, then the technical committee was formed. Prior to that, what happened to that extent, I will take instructions. So 2019 to 25. However, we have issued several communications to the LNTC when we have conducted field verification also. Along with high-ranking officials, the field verification were conducted. There were several defects, which were also corrective measures were also suggested as to how those defects can be corrected. But then thereafter also those defects were not corrected by LNP. Then accordingly the show cause notice was issued to them. But then LNP has not yet answered to our show cause notice. Herein they have been arraigned as opposite party number 5 and 6. Notices will also be issued to them.
Opposite party number 5, you represent executive engineer. Opposite party number 6 and 7. 6 and 7.
6 and 7.
7 would do. 6 is Chennai. That is,
Applications have been to the clarification.
Already managing all the others.
huh.
The entire money has been taken by the LN.
There's no managing director under the land. Larsen and Toubro.
Hmm.
There's no CEO.
The field verification was also conducted on 30.
Madam, everything was done in 2025.
Yes.
What you were doing from 2019 to 2025?
If there is any-
That shows that you were just sleeping in a slumber. Now you are justifying that the government has activated the process, show cause notice. But how to ensure that the water is supplied to them?
Action has been taken to that.
That now nearly 1 year has gone. Still you are at the show cause stage. You are just waiting and giving more invitation that you come and give a reply. Have you not given a timeline within which they have to give a reply in the show cause?
Yes. 7
Then-
days.
So, if it is the 7th of January, now we are in the first week of February. What you are doing? Why you did not immediately take steps after 7 days when they did not give you a reply? What you are doing? And they are just craving for the water to be supplied to their villages.
This is just 80 kilometers from here. From Cuttack, it's or in undivided Cuttack district only.
Yes, ma'am.
Yes.
Two areas, Narsinghpur.
Ah.
and-
Narsinghpur and Badam.
हाँ
Yes.
आगरू कटक रहथिला कटक डिस्ट्रिक्ट हाँ
Now, so it is.
To conceive of a project and to start a project, that's a very, very good initiative that has been taken. Still, the country is the major part of the country is deprived of their water at their doorstep, and that too safe and the I would say hygiene drinking water. What do you expect?
This is at the Mahanadi river bank only.
Yes,
This area.
217.
75-80 kilometers off Cuttack.
You're directing who is the in charge of this project?
Engineering team.
Executive
is the-
engineer
which
Athagad.
department?
Athagad.
Which department?
Water supply and sanitation.
And this present restriction was defined in a form of public interest litigation. The sole nuance of the petition is that manner, since log is a 5-kilometer road under Baleshwar municipality, but happens to be the worst condition when unauthorized persons had occupied the lands, the government had taken a decision to improve the road in order to avoid the accident, as well as to develop the communication of the person, as well as to sanitation process. It has been developed and fund already sanctioned. Last 3 years, fund already sanctioned for renovation of the roads. I decided to 5-kilometer road should be punished in a better way for that, for safety of to avoid a road accident. What happens?
This particular road which you have passed.
Yes,
You did not submit that the other one of the cases. The case was pending and individual has passed interim order and you did not bring it to a notice.
No, my lord, may I submit, your lordship? My lord, may I submit that is the lead petition, the PIL, the nature of PIL, that is to 1/6/2017, 2025 was before this before your lordship. And my lord already disposed of on that day, that is on 9/12/2025. And also on that day, I had submitted that some matters were pending already disposed of, and I had also, my lord, submitted as the certified copy. And my lord,
You did not bring to the notice of this court that some matters are pending before the single judge.
No.
And the other single judge had passed interim orders.
my lord, now the single judge of that their petition already been disposed of, and this review petition has become infructuous because I'm also that is submitting the already the order of the honorable single judge that has been passed and direction given that all the encroachers. Your lordship, see. My lord, already that review because of the pending.
Including this, you filed an affidavit.
Disclose whatever the disposal has been done. Disclose, say that there is no obstruction.
Yes, no, and only obstruction is there. A review petition is pending before this, which is infructuous. My lord, let it come next, my lord, along with this, and this will be disposed of because I will file the affidavit because this is the certified copy of that order, my lord. The already disposed of this single judge order, and direction is given to the municipality as well as the administration to evict all the encroachers in the Baleshwar town, my lord. This has been already. There is nothing. Well, OT road. Yes, see the same case. It is the same case, my lord.
This is also OT road.
Yes,
This
yes.
is OT road. My
Yes.
my expert submission, the government is the competent authority to take a decision.
That what we are
Not
talking
only-
about,
not only-
if some of the encroachers have already
Yes.
approached this court and have obtained an order of stay, do you need not an order to defy that order?
Already,
So
my,
you can let them disclose
yes, yes.
that what are the cases which are pending and what are the cases which have been disposed of, what is the problem which is really standing in the way of
Yes.
completing the project, let them come with that.
It's
But,
only one case is pending review. This come,
Yes.
let it be listed along with this.
disclose, we will list it.
Huh.
Give the number.
Yes, yes, I will give it. As a giving, that is RBWPT number 294/2025.
Review of this division makes a decision.
Yes, man, only the party which was not made party, here file review. Only because of this, only this process has been stopped.
Single, before the learned single judge, all the cases.
All the cases disposed of. I've got this
You
article.
file an affidavit.
Yes, I'll file affidavit and your lordship that it come along with in the press admission.
And clearly mention about.
Yes.
Lot numbers.
Yes,
Unit.
everything,
And
man.
the Moza.
Yes, man, I have everything.
Review number.
Give us list number.
Yes, they. In the press admission, day after tomorrow or next week. Any day I will file the affidavit.
Very first.
Yes, affidavit.
You are speaking from Balashwar municipality,
Yes,
7. Of report number 7.
7.
Right?
Monday, yes, that's Tuesday. Next Tuesday, display listed
10th.
in the heading of the press admission.
Item
कॉपी दे दें।
हम दे दी ना
नहीं, affidavit करके साइन करके copy दे दें।
कॉपी दे दी हम कल पढ़ना दे दो
item number 7.
That in this matter, Mr. Jinnah is appearing for the commissioner. He was here, Peter, just to inform that he is suffering from a head drilling. He went to dispensary. They will take it up next week.
Yes.
Item number 8.
Really the files for a direction to the opposite party number 2 and 3 to evict the private of opposite party from the government land.
Well, the date had been fixed to 31st of January for eviction. On that date, my lord, a request was made by the encroachers for demarcation again. So demarcation was done yesterday. But my lord, it was found that they are encroachers. So my lord, a 7 days notice has been given, and on 8th, that 7 day ends. On 9th, my lord, we'll carry out the eviction. My lord, any day after 9th, my lord, may call. My lord, sir.
Item 9.
May I please allow? But last occasion, Lama State Council seeks time to take instructions. The payer to evict from the public road.
What is the instruction about it?
Yes.
Well, it's a joint verification will be taken up so as to ascertain the field situation. We'll file an affidavit to that effect, enforcing the report of such field verification for 1 week time. 2 weeks time. Yes.
Report corroborates his case.
Yes.
Action has to be taken. Why not you take an action of your own? Why the court will remind you to take action?
Then it's based on the findings of such field verification, then appropriate action.
Exactly. You are already contemplating for a field verification.
Yes, sir.
And then in the event it is found that a portion of the government land is enclosed or a government land is fully enclosed, some action has to be taken.
Yes, ma'am.
So
So then I'll file them, and after any action has been taken, then after that I'll
when
file.
you are going to have the field verification.
Well, it's in the next date.
This is the approach since 30th August 2024. Yes, Lord. Under annexure 3 series. It's more than 1.5 year last year. At least 30 euros.
I can't read.
My lord, it is in Odia, my lord. Sorry, my lord. I will give the translate.
This was taken as a project to clear off Old Town and make passages clean.
My lord.
This is an Old Town.
Airport.
Airport road, my lord.
Ah.
Airport road.
Linking to
Airport and Lingaraj temple, my lord.
Lingaraj temple.
My lord.
So that area was not that made the passage.
No, my lord. No, my lord.
Widened the roads and all.
Manoj?
There was some acquisition and some steps were taken.
No, Manoj, there is no step has been taken, Manoj. Clear.
To take the necessary steps. Now it's kind of some time. We'll have.
Item number 10.
Lords, I am on virtual mode. Lordship, kindly see the order dated 13/1/2026. Direction was given to implement the orders of the Supreme Court. Your Lordship had called for the report 13/1/2026. The operative portion is paragraph 3.
In this matter, Miller, the proposal made by the High Power Committee has been accepted, but has been approved by the Law Department and other departments. Miller, as per today's instruction, Miller, it's approved by the government, and we are heading for notification. Let's see, may call on this matter next week. I will come with the notification, Miller.
He will come up with notification.
That in this matter, we are filing counter affidavit today, Miller. I will sort the copy. Yes, they will taken up next week.
Right.
I will sort it out.
Has been filed. It is submitted, but affidavit.
Item number 12.
Worships, we are the villages, Worships. In 2017, Lordships, under the Government Capital Asset Scheme, a process was initiated for the construction of a Kalyan Mandap, Lordships. Subsequently, we were allotted 35 lakhs of rupees. Then a quarter payment was made of 10 lakhs to the concerned PEO for continuation of the work, Lordships. Then subsequently, the work order was sanctioned and substantial work up till the rental level of 8 lakhs of work was done, Your Lordships. Then subsequently, in 2021, Your Lordships, a CRL was filed before this honorable court, Your Lordships, as to the government funds are being misappropriated, Your Lordships. Then, then the honorable High Court has instructed, Your Lordships, as per annexure number 1, Your Lordships, to the DSP Vigilance as to carry forward an inquiry and take effective steps for completion of the inquiry in accordance with law within 6 months, Your Lordship. In 2021, this order was filed. Then subsequently, Your Lordships, after 4 years in 2025, as the Kalyan Mandap work was being stopped just because of the fact that the CRLMP order was made by this honorable court and the inquiry is being conducted. Then after elapsement of 4 years, your lordship, we have approached the RTI, through RTI to the vigilance authorities, your lordships, as to what is the status of the inquiry, your lordships. Then your lordship may see the annexure number 2, your lordships.
Kalyan Mandap remains incomplete. Kalyan Mandap construction
Is
remains incomplete,
Yes,
pending further decision.
your lordship must see the findings of the inquiry, your lordships. The sole allegation in this CRMP was there was corruption, your lordships.
Now, who is to take a decision?
Your lordships.
Who is to take a decision?
Your lordships, the BDO, opposite party number 2 and 3, your lordships.
Lords, I have obtained instructions from the BDOs. You know, the BDO says, my lord, that the inquiry is not completed, that the inquiry is still going on. And therefore, my lord, we are not progressing with the construction of the Kalyan Mandap.
Lordship may see the annexure 1, your lordship. On 5/1/2021, the order was passed.
You have flagged an issue. ERLMP was filed, the court has directed the inquiry to be done. And this is what is the embezzlement. You have to complete the inquiry within a time frame. It is not a perpetual one.
Lord, sir, here the inquiry has been conducted by the vigilance department. My lord, I do not represent the vigilance.
Sir, this court directed in the year 2021.
Yes.
Please
my
keep
lord.
it in mind.
Yes, my lord.
So now we are into 2026.
6 my lord.
So,
But my lords, we are not conducting the inquiry, my lord. Vigilance is conducting. My lord, I do not represent the vigilance, my lord. They have to make them a party in the notice as to go Mr. Srimanta Das might appear.
The vigilance is beyond the conceivable powers of the government.
No, my lords, but they have their own special counsel, my lord.
So what? Why not? That is what I have been seeing or hearing since last many years. Why not? There should be some kind of a synergy or a convergence amongst the different departments of the same government. That's the irony of the thing. Not my responsibility, their responsibility. They say not mine, their. But the thing is, bottom line of the entire episode or a story is, work is never done. It is simply a passing a bug.
Lord, the thing is, my lord, I cannot obtain instructions from the
Sorry,
vigilance
why can't you obtain? You are a government advocate. No, a separate panel of lawyers. So what? Is the Advocate General? He represents the government.
you have not made vigilance a party.
No, your lordship.
The Advocate General represents the other party, not the Vigilance Department.
They have also not pleaded the vigilance as a party, my lord. So
Whatever be, when a question was there, it's an Advocate General's office who has to do it. Will they not
my
ask?
lords may pass that order, my lord, on the basis of my lord's order.
So you should be reminded of your responsibility.
My lord, the thing is, my lord,
He represents the entire state government. So if he says that you give me, will the Vigilance Department say I will not give?
my lords, I'll ask my excuse. I'll ask my excuse.
Mr. Sanjay Rath, that additional government advocate. Say 6.
This is the pattern they are not having.
So may I pray for one fast over it is allocated to Mr. Sujipur Das.
Item 14.
Council.
I'm appearing for opposite party.
I have obtained instruction in this matter, Miller. The sole grievance was that, Miller, the opposite party number 3 is operating a rice mill without having consent to operate from the Pollution Control Board, Miller. This mill. I have obtained the document, Miller. In the meantime, the Pollution Control Board has granted consent to operate in favor of the opposite party number 3.
I'm also filing my counter. In the counter, I have annexed all this permission I have accorded.
Page 7.
What? Disposal on their cases. The only issue was this, they are regarding the running of the rice mill without any requisite license and the permission. Affidavit shows that every permission has been granted and therefore not substantially. Yes. All the names.
Item 15. Item number 15, sir.
I think the.
Sir, may I Sir, may I be permitted to submit my. Sir, this is a public interest situation.
Not that, the trees and plants, this is health mission.
Yeah, that's apologize.
You are representing health mission.
Sir, yes.
But in this matter, Miller, may raise a preliminary objection, Miller, in this matter. The
Health
public
mission.
interest litigation has been filed relating to this matter here. And this paragraph 3 and 4 of the requisition shows that, Miller, she has claimed that number of persons are retrenched, other persons are retrenched from
Under
government.
the Industrial Dispute Act,
No, Miller.
retrenched.
It has written that, Miller. Retrenched. Without this giving any opportunity of hearing her, without giving any notice.
So this relates to a service matter. Yes, madam, on a preliminary objection on the maintainability of PIL. Service matter, how can there be a PIL?
Sir, this is related to the health of the public. The HM deals with the maternity and total public health of the entire country. And this.
What is the prayer which she has made in the writ petition?
Sir, my prayer is.
What is the relief?
Sir.
16 number of prayers have been made.
What are they, those?
11, 12, Lord, it will be, this is that the authorities, state government as well has arbitrarily retained some persons, Reveking 11 and 12.
What?
And see what working.
So it relates to a service.
So, not only related to the service, sir, this is also related to the
Show us the judgments on that this public interest litigation is not maintainable if it touches upon the service.
No, not only.
Either the service conditions of the employees or a service related matter.
No, sir. No. This is also related to transparency, disclosure of guidelines, and prevention of arbitrary HR actions under a public health mission, who deals with the health of the patients.
How can you policy governing the engagement? How can you do that? First prayer cannot be granted in this fashion.
Sir, this administrative failure within the NHM should be sir, sort out and
Yes. Now there is a judgment of the Supreme Court in Girjesh Srivastav matter.
Sir.
The court has also noticed the earlier judgment of the Supreme Court in Duryodhan Sahu.
Sir.
That is a 3-judge bench just says no, it does not, it's not maintainable.
Sir, it is not related to the service and not related to my personal
Then
relief.
first
sir.
prayer is to lay down and implement a clear, transparent and uniform policy governing the engagement service conditions. What are you talking about? Then disengagement of NHM, it is again relating to service. Then all engagement and disengagement orders of the contractual employees are duly published and such to maintain transparency. What is the service matter? Then redressal mechanism, no contractual employee is disengaged, service matter. Periodical review of the contractual implement the engagement policy, service matter. What more? Compensation and reinstatement in the cases of a correct service matter. Please look at this judgment of the Supreme Court. We are bound by the judgment of the Supreme Court. We can't go beyond that.
Sir, it is also related to non-utilization and misutilization of contingency and consumable funds, and of course direct suffering to patients and the public also.
That is all related to service. How can it be maintained? You go through that judgment of the Supreme Court. You'll have to meet the requirements.
The contingency and consumable funds are
This
not.
is again followed in a recent judgment. Oh, of this court. In Hasmina Kumari Das. This is again followed. Cannot be done.
And this
Madam, sorry.
Dhabesa is also followed.
Sir, misutilization of contingency and consumable is not related to the service.
No, madam, you can't. Your primary reliefs are of such nature. We can't segregate those. You may come with the multiple prayers, but the main focus is on that. So it cannot be. If it is a service that appears to us, then Supreme Court in clear terms have says no PIL lies to a service matter.
Sir,
We are bound by the decision of the Supreme Court. We can't go beyond the decision of the Supreme Court.
Sir, may I grant another date to
Come in the next week. You go through it. These judgments are there. They have relaxed.
Sir, much
A preliminary objection is raised by the additional.
Item 16
No, he is not appearing. He's appearing.
No. Now he is petitioner.
Now 16 is the petitioner.
Yes,
They seek one week time.
at the request of Mr. Ramdas for the petitioner.
Item 17.
But item 17 also not essentially was the last one possible maybe granted. 17 and 19 also were.
Yes.
Item 8.
1 week. 1 week of
Item 18.
at the request.
File. Withdrawn. Yes, next.
Item 19.
Pass over.
No. Counsel for petitioner is an absent.
Item number 19.
Please, slow.
My lord, though in this review application petition was
He seeks for an accommodation.
Yes, my lord, in fact, though petition was challenging in this application for tender call notice, in the meantime, got information tender already cancelled by the
So
authority.
what remains?
So
Then
may-
you file infractuous. Oh, recorded.
May,
Yes, yes. The challenge is made to a tender call. You a liberty to withdraw. So no question of liberty.
No tender, no cause of action, sir.
Next.
Item 21.
Huh?
Election Barik. Yes.
21.
21.
The petitions are villages on the Chandipada Tehsil has challenged the notice of the State Pollution Control Board. The English translated copy after my order will be annexed of high. That the notice was served seeking public hearing to convene on 24/9/2024, and wherein the State Pollution Board sought for the views, suggestions, comments, and objections from the local people. That has been given the definition of the persons that a person likely to be affected by the grant of environmental clearance, any person who owns his control with respect to which an application has been submitted for environmental clearance, an association of person whether incorporated likely to be affected by the project or functioning field of any local authority which they are part of whose limit is within the project purpose to be located. Here the notification was made, but by the agency of the proposed company, that is Gujarat Mineral Development Corporation Limited, by taking the main and agent, the meeting was concluded. But the local people actually were not allowed to enter into the premises.
Did you lodge a complaint with the police? Did you lodge a complaint with the police
Well, yes,
on the same day?
well, they were present. Well, there is a video clip. They did not allow these people.
I am asking you, so ask him. Loudly.
Have you not lodged any complaint before the police?
Police, I have not.
You are restrained, so wrongfully restrained.
No, in all query it is found that annex of 3 and 4 minors. Well, can you turn to annex of 3 and 4? These are the notice were issued by the annex of 3, the notice issued by the central government for allotment of one open cast mine for
Not understanding.
Your plea is
the objection was given to the district collector that he did not entertain mine.
where has he refused? Where is the rejection?
Given any communication to this petition?
On the day when the hearing was going
There
on,
is
he
no
was prevented.
communication.
Will he not go to the police station and say that how can they prevent me from entering? I'm a villager. Did he lodge the complaint?
If you were present at the village during the course of hearing
Well,
and you are restrained or prevented from,
district administration, the
so somebody prevents you from attending a meeting.
There are 7 villages, my land.
So you should have made complaint before the police. How can somebody prevent you?
But they have
From-
given their objection to the district magistrate, district collector HON'BLE, who did not respond to the.
What is the difference, right? When the meeting was held and when different?
Where is the complaint? Where is that document, sir?
That only representations, last representations, that is under Annex 9 series. That the complaint I will give you.
Where have you stated that you were prevented on that date when the hearing was going on?
Stated in my petition.
No. Where is the document? Where have you raised that objection?
No, frivolous.
The video clip with the
No. It's a frivolous also.
with the petition of the video clip, they have requested to.
This is after talk. No.
Yes, they have come to him and then. No. Absolutely. Yes, who is for?
But the fact remains that in 2017, one notification was made. For
Whatever is there, what do you say?
I think it's.
What is Don't you read the brief?
They are challenging a notification of the Pollution Control Board.
Then what is your stand on the basis thereof? After reading it and after reading those facts which he has disclosed, that pursuant to that, there was already a public notice which was invited hearing. They were everybody went there. After participation, a conscious decision is taken. Now, there may be some of the persons who have some grievances, but the public hearing was done. True.
This has to go to Pollution.
Why should? Unnecessary. His allegations are there is no no document which is substantiating the same. That is your brainchild, sir. When they come to you, you know how to tailor it. Sir, if they were prevented in their representation, will they not refer? In the complaint, will they not write one sentence? It is when they come to you, when you draft the writ petition, you say this is what you have to say.
7 villages.
Sorry, we can't. If the hearing was a public hearing was done, order has been passed.
No order has been passed. So far as there is in office, there is no website or phone number which is contained in the notification.
If there is no order, then it is premature. If there is no order, then it is premature. If the order has been passed,
the objection
yes.
I provide on the next time.
What objection? Objection to what?
That they did not allow the petitioners.
Where you have said, sir, in your representation, in your complaint, tell us.
Sir, one thing. The State Pollution Control Board advertisement or notice, whatever, you have challenged Annexure 5, that is dated 22/8/2024.
Oh my God.
Wherein your opinion was sought by 24/9/2024 being present at the venue, right? That was 24/9/2024. Your case is the villagers came on that day. Villagers were prevented from attending the meeting, right? On 24/9/2024. Then you are citing Annexure 9. Annexure 9 was given to the collector and that was received by a collector's office, it seems. Somebody has received. There is no seal and all. 17/1/2025. So October, November, December, January, you took 4 months.
On 17/1/25 also that pollution board. It should be compliant. On 25/1/25. That is at page 45. I have given the annexure in my.
That was also 17/1/2025.
17/1, yes, sir. But 24/9 the meeting was convened.
What constrained you not to approach the authority on 25th September, 26th September, 27th September, in the month of September, in the month of October, in the month of November, in the month of December? You just slept. Only on 17th or 7th of January you woke up.
What aspect, my lord, they collected some document that I am submitting, my lord, in 2007.
Sir, your basic point is that you were there on that day and you were prevented. That is what we are more concerned, that once you are prevented, will you sleep for 5 months? Will you sleep for 5 months?
The objection.
Or 4 months, whatever.
Some villagers.
And
have
that
objection.
document, Mr. That document which I have read, somebody has received, that is a created document, but seal of collector, it's collector's office that shows 26th March 2025. Another one that is dated 17/2/2025. That is
When there are
given on
objections were not
26th
made,
March.
these are the subsequent representations, man.
Sir, my question is very simple. 4 months, what you were doing?
What happened, my lord? There
Have you stated?
meeting. The meeting.
Have you stated? Don't make out a case at the bar.
No, I'm
So you are a creature of instruction and your responsibility is to plead. Do not make out a case. Have you stated anything about 4 months in your petition?
That 9 pages, the petitioner could not know about these things are going to happening behind their back for Gujarat Mineral Development Corporations. As many as in 2000.
Sir, a very basic question you are raising.
This one I am giving this.
Sorry.
Kindly, my lord, this is a notice I have not given annex to that document. That is a very big document, my lord, so that they could not include it in Annexer 1. In 2017, my lord, one notification was made for Orissa Mining Corporation to for acquisition of land for prospecting coal mine by Orissa Mining Corporation. That has abandoned. Then subsequently in 2023, made for transferring this mining
For
operation
orders, keep it.
for a outside
Put up
company.
pressure.
Not today, can pass.
No, there is no pressure. Don't.
The outside company was then this 2017 notification, all its license, statutory clearance, permissions, all etc. was scheduled to
List this matter.
transfer to a outside company, that is Gujarat Mineral Development Corporation. And for that, this state pollution board, as per the EIA Environmental Impact Assessment notification, this public hearing was conducted.
Item
Pass the-
22.
We'll pass the. Don't.
22.
But 22 years back, meteorology may recollect that pendency of pollution certificate. Pendency of challenge are not a bar for getting pollution certificate. And I have filed a affidavit today. That is not your lordship.
We will read the affidavit today. If there is now no substance in the affidavit, then what?
I brought before your lordship certain clarifications issued by the central government.
What is this? No, this is the Snigdha Patra. There of.
This of notice. To find out. That notice was issued.
So 5 and who is appearing? 5.
6 months.
5.
I provide notice sufficient, but
Yes. 9.
9 minute notice would not be resolved. It is in transit.
Come the next.
I'm a fair person.
No. Yes, record the appearance of all the persons next week for 9. In the meantime, you find out when 9 is served. Yes.
Have you served copies of?
And you
this
copy of the affidavit you serve. No, this is not required. Is the affidavit a service?
No, this affidavit. The
No,
service.
it's service.
Oh, it's.
Just keep. Let the affidavit of service filed today be taken on record.
This is, you have.
The affidavit filed and you brought on.
Yes. Be also taken on record. Copy served. Serve the copy in course of this day. By tomorrow.
Opposite party move on and.
By tomorrow. This is the matter on such.
Item 23.
I will call in this matter next week.
Awaiting service. No? on
Opposite party number 9.
If your lordship, in this matter, instruction was asked from the government side. Regarding
They are not giving instruction.
your lordship, the road, public road, villagers utilizing that road. And in the map and in the ROI.
Only the villagers are utilizing that road. What about cattles?
Cattle.
Cattles are also using the road.
Guides on some.
Yeah.
Matter is that. Hey, forcibly unauthorizedly, opposite party encroach some portion of the road. So that it is not.
Yes. Thick.
I don't know, 26.
For instructions from the opposite party. Paying for one point over.
This is some kind of other matters not.
This was fine. Food ration.
Yes, brother.
A tender was floated. Annexure 2 Malots for supplying food to the hospital Malots. And that is at running page 35. The agreement was entered into on the 2nd of May 2025. And page 37, period of engagement. The engagements shall be for a period of 1 year from the signing of contract with effect from 1/1/25 to 31/12/25. It will be extended for another year after satisfactory performance as per due assessment. Page 37, if your lordship kindly sees, fuel for cooking, period of engagement. Lordship gets it. Now, so 1 year, if I perform satisfactorily, I'm to get an extension for another year. Now, my lords, I have annexed my performance sheet, Annexure 3. Onwards it goes. Everywhere your lordships will see good, excellent, good, excellent. So obviously my performance is satisfactory, my lords. More than satisfactory, it is excellent. Still then they bring about a fresh rate. Contrary to this clause. Annexure 1 is the new tender which I am impugning before your lordship. Lordship sees my performance. Good at running page 43. Good, excellent, excellent, good, excellent. And this is given by the medical officers, my lords. This is from the office of the superintendent, Udala Mayurbhanj. Staff behavior good, food delivery good. You have made representation.
Yes, Annex 4. In view of my excellent performance, good performance, I made my the representation and it should be extended for 1 year. And till today I'm continuing, but they have brought forward the intent.
First time.
No. He has argued that in the agreement,
Yes.
it is stipulated that satisfactory work is done. And that can be extended. The original agreement was for 1 year. So he is still continuing. And he has enclosed annexer three series. Showing that all the days he has performed excellent, good, very good. Nowhere it is bad.
Yes.
Still then, his representation is not taken up. Yet that was given in November.
Yes.
But in January, you have floated a request for proposal. Answer 1.
Yes. I have to take instruction, my lord. The first time it has gone.
Date of the tender is basket second.
Second February.
Yesterday.
Yes.
Technical proposal is 4th February.
Yes.
Tomorrow.
Tomorrow.
His representation. They are not reported any instruction.
My lord.
You have not taken any instruction.
No, I have not taken any. First of all, let it come on Friday, my lord.
No, Kaizen it will do tomorrow.
Tomorrow. Tomorrow is the day
Tomorrow
for
is
bid.
first.
Tomorrow.